For your question.
Doctor, and well said. And I suppose, this is so important for all of us, and timescale, I believe, is a huge issue here. And where we see in other EU countries, they use the family law framework, and this is important in how we approach this. But we don't have a cut and paste, as you said in your statement. But would it be fair to say we just don't have anywhere this is covered properly in Irish law? And when you spoke about the approach, you said there's the strict, the moderate and the liberal approach. Can I just ask you, what way do you feel that would be the best option for us? Or do you feel we need to maybe address some of them? Like if with the three options, we always need to find a balance, and I'm just wondering where do you feel that should be addressed? My other question would be, Doctor, is can you tell me about the judgment in the UK this week? I'm sure you're aware of it, and maybe if you could give me your thoughts on this. And my third question is, and I just want your opinion on this, what would be the best way that we could have fair compensation for surrogates? And I'm speaking about medical treatment, maternity benefits, which has been a big issue that a lot of people have come to me about, whether it's for the surrogacy mother or the birth mother. And there just seems to be, funding is a big issue, as you know yourself, and we need to address this. But they would be my three questions, and thank you very much for your opening statement.
Thank you, they're all really interesting and complex questions. So I'll take them in turn. So I think your first question was that this wasn't covered properly in Irish law as it stands. So that's right. So the committee are aware of this, but essentially the way surrogacy is governed in Irish law at the moment is that there's no special law for surrogacy at all. So you can get into a surrogacy arrangement, you just fall under the general provisions of Irish law. So essentially and I've acted for couples in this situation in court, when we're dealing with it, we're just bending Irish family law to try and make surrogacy fit into it, right? And that is the reason why there's no way for the genetic mother to be recognised as a parent, because under Irish law, the mother is the birth mother, and there's no way to ever change that. That's an unchangeable rule in Irish law, okay? And whereas there are provisions for unmarried fathers to become parents of their children, to be recognised as parents of their children, and then to become guardians. So that's the law that an intended father uses. So exactly, there is no special law for surrogacy, and Irish law just sort of has those general rules, and then you try and fit surrogacy arrangements into them. So that's the reason that we need to look at what we do about that. And I think it's useful to think about at the outset, though, that there will always be arrangements that are not compliant. So no matter how thorough your regulatory framework is, there will be some arrangements that just don't fit into that, and they can't get a parental order. And probably they'll fall to be regulated by the general provisions of family law anyway. So that's just something to think about. No matter how well you regulate it, there will be that category, and they may end up back in the world of family law, general family law, which may include adoption. And that's just something important to think about. In terms of which option is best, I mean, I would say just, that's a sort of taxonomy of those three approaches that I've just sort of presented for the ease of the committee. They're not, set in stone, they're not gospel. Yes. My own view is that a moderate approach is probably the most pragmatic. I think the difficulty is that if you have a completely strict approach, there's no way to recognise arrangements from, that are international. You don't have any way to accommodate them, right? Okay. So you're just going to end up with a very strict domestic surrogacy regime, and then people still trying to be accommodated in adoption law and family law. And that's the tension. Like, you don't necessarily want to accommodate absolutely every surrogacy arrangement, because there will be arrangements that you're just not comfortable with, that there are ethical problems with. Of course. But there are shades of grey in surrogacy. That's the thing. There will be commercial arrangements that you will encounter where, there really aren't any serious ethical issues. As long as you set aside your basic concerns about paying money, you will encounter some that are not deeply problematic. And it's about the work of this committee, I think, is thinking about that middle ground. Yeah. The judgment in the UK, I'm not sure which one you're talking about, actually, so maybe you might tell me a bit more about that.
It was the British judge ruled this week that a couple that are legal parents of their adult son under English law, the judge said the couple's son was born in the US in 1998 after they'd made a surrogacy arrangement there. The couple visited the surrogate mother in the US during her pregnancy, the judge said, and returned to the UK when their son was a few days old. And the judge said the couple had been their son legal parent under the US law, but not under English law. That was just happened this week, so I just was wondering what was your opinion. I'm familiar.
So the difficulty with that is, so this is the kind of time frame problem, is that they hadn't applied for a parental, they hadn't regularised his status early enough. So they've had a lot of problems with this in the UK, where there was originally a 6-month time limit for recognition. And that was a problem, because the courts, if you didn't get organised in 6 months, then you couldn't get a parental order. And the UK courts actually bent the language of the law so much that they actually sort of disapplied that. But I've noticed that the draft legislation here actually allows for extension of the time, which is very, very clever rule, I think, in my view, because it's actually foreseeing that problem that the English courts had.
Yeah.
So I think the difficulty there was that the time had just elapsed, and you know, he was an adult as well. So that's sort of a feature of these cases. Like, you can't make orders. Say in adoption, you can't adopt an adult in Irish law.
Okay.
And once the child gets to 18, that's it. You just can't make an adoption order. So similarly, you couldn't make a parental order because as a matter of law, the person doesn't have parents in the sense that children have parents. You know?
Okay.
Your final question was about compensation. So yeah, I mean, this is a really interesting question. So how do you fairly compensate the surrogate? And I think that's an interesting thing. Like, you know, if someone is being a surrogate, right, you might not like the idea of commercial surrogacy, but you probably think they should be compensated in some way. I note that the draft legislation has actually relaxed the rules on this. So originally in the general scheme, the legislation, I think, restricted payment of reasonable expenses so that the only sort of significant sum that you could accrue was 2 or 3 months out of work, I think, whereas the current legislation allows for the payment of 6 months around sort of like loss of earnings, essentially, around the time of the birth. I think that's quite reasonable. Yeah. I think that's quite, you know, whereas 2 or 3 months is not an awful lot of time. Don't have a huge difficulty with that personally. Like, as I say, these are kind of personal ethical judgments as well. You know, like someone like me can give you a steer in what I think, but ultimately it's for you guys to make your, you know, your judgment on that. But I think the regime is quite good in terms of what's in the AHR bill as it is.
Lovely. Thank you very much. Thank you.